Yes, Your Honor. This is a transfer petition. I'm requesting for listing of an IA for seeking stay, Your Lordship. The reason is that the trial before the trial court, the matter is coming up on 1st of September.
Some date in August.
I'm grateful.
The matter is the matter is on 13th of August, my lord.
Which case?
Balaji Mandir Punch Committee versus Purushottam and others. I am appearing on behalf of respondents.
No, which matter?
Yes, I am mentioning.
Oral mentioning or listed mentioning?
Mentioning.
Unlisted mentioning.
My lord, I have also moved an email for mentioning my lord.
Sorry, unlisted mentioning we don't mention.
Kindly allow, I have moved in 4 days back. My lord, the respondents are taking petitioner taking third party interest, my lord.
Thank you very much, sir. We don't entertain unlisted mentioning. For that, you have to go before Honorable the CJ or as per the procedure. Thank
Yes,
you.
my humble request is that I have.
Thank you, gentlemen.
Item 1, Rudy is your lordship.
My lords, I'm appearing for respondent 2 accused in this matter, my lords.
My lords, I am appearing for respondent 1 state.
You have moved
For the
an application for adjournment.
My lords, I have moved objection to that, my lords.
We have seen
the
that.
reason being, my lords,
Because the trial court is not proceeding with the.
my lords, not the trial court. There is one connected offence under Gangsters Act. I have been granted bail in all other matters. Now, in this offence, my bail is pending before High
We
Court.
have seen that.
And I would be otherwise statutory entitled for bail under 436A of CRPC because I have been in custody for more than 6 years and under Gangsters Act.
You are, gentlemen, please proceed to argue.
My lords, I will assist.
Argue.
My lord,
Argue your matter.
my lords, I will assist. My lord. Now, my lord,
Argue your matter.
my lords would kindly see there are 15 witnesses. I am assisting my lords on merit only. My lord,
Even what we are saying is, please proceed to argue your matter.
My lord,
Because,
my lord.
see, we are opposing his adjournment.
indeed, my lord.
We are disallowing his adjournment.
My lord,
Now, bail has been granted to you in a 302 matter.
my lord, please.
Let us proceed.
My lords, may
Whether
kindly
that-
have.
Whether the correctness of the order is an issue.
Indeed, indeed.
Proceed.
Now, my lords, may kindly have my counter for a moment. There is the
Counter,
chart
we
of
are not-
cases.
We are not going into the counter.
My lords,
Counter, we have seen the counter.
my lord, there are 3 grounds primarily on which my friend has moved for against that order. My lord. First, he says about pace of trial. Now, my lords would see,
Kindly come to page 6 of the counter.
my lords,
Counter of respond number 2.
my lords, grateful, my lords. Page 6 has the para 15 has the chart. One, I have been acquitted.
Correct.
My lords, in 4, I have been granted bail.
So,
5th is this case which is before my lords.
so,
And 6th is that Gangsters Act.
so,
Now, my lords, may
now
kindly
you
see.
tell us why should we not cancel your bail?
Now, my lords, may kindly see there are 55 witnesses. There are 55 witnesses which are to be
Correct.
examined.
Correct.
As of now, only 15 witnesses have been examined.
13,
Last
13 or
6.5.
15, whichever it may be.
They say 15.
Well,
Court order says
No
30,
problem.
but in the meantime, I believe 2 more witnesses have been examined.
yes.
So, 15 out of 55 in last 6.5 years.
Yes, please.
Now, my lords, may see the complainant. Now, complainant in this very case has named some people in the FIR itself. Now, in that case, eventually closure has been filed against those accused persons and complainant is alleged to have forged the document of court record wherein he forged the affidavit and court has proceeded to take action against him
He may be
for
a rogue.
implication.
He may be a rogue.
My lords,
Gentlemen, he is a rogue.
my lords. My lords, now
But-
I am not
but
present
we are-
at the spot.
We are not examining
My lords,
his locus.
my lords,
He is the complainant.
my lords,
He is a rogue.
my lords,
Whatever wrong he has committed, the
Right.
law would take course.
my lords.
Correct.
Right.
We are into the bail correctness of the order of
Right.
bail granted. in-
Now, my lords, may kindly see the reasons which have been given by the High Court by granting bail. One is the slow trial. My lords would kindly have the impugned order for a moment.
We have it.
My lords. Now, there are reasons which have been specified. First is that the trial is proceeding at the snail's pace. it says that 13 witnesses. Now my friend says 15 witnesses have been examined out of 55.
We will only
Now-
want you to do one thing.
High Court also says,
Gentlemen, just
my lord,
we will only want you to read the 4-page bail order.
My lord.
Right,
My lord,
right
great.
from the word.
Great.
Right from the word. Judge, you need the name of the judge.
My lord,
This is the first bail application.
Great.
Now read till end.
grateful, my lord. By means of bail application, the applicant has praised to enlarge on bail in crime number such and such. The bail application of the applicant was rejected by learned trial court on 9/10/2023. The following arguments made by such and such learned counsel on behalf of applicant, which could not be satisfactorily refuted by such and such learned counsel for the informant. And Sri such and such learned AGA from the record entitled the applicant for the grant of bail. 1. The applicant was not named in the FIR or in the statement of first informant. 2. The principal offender to the contrary have been nominated in the FIR. 3. Prosecution case does not attribute the role of shooting at the deceased or to the applicant. 4. Role of the criminal conspiracy has been assigned to the applicant. Prosecution evidence does not connect the applicant with the offence of conspiracy. 5. The applicant is a law-abiding citizen who cooperated in the investigation and has joined the trial proceedings. The applicant never tampered with the evidence nor influenced any witness. 6. The trial is moving at snail's pace and shows no sign of early conclusion. The applicant cannot be faulted for the delay in trial. Status report sent by the learned trial court in the bail application of co-accused records that the prosecution proposes to examine 55 witnesses. However, only 13 witnesses, including material witnesses, have been examined. Learned counsel for the applicant calls attention that the witnesses are not cooperating with the trial proceeding. Clearly, the prosecution witnesses are delaying the trial only to prolong the incarceration of the applicant without there being any evidence against them. Inordinate delay in concluding trial has led to virtually an indefinite imprisonment of applicant without there being any credible evidence to implicate him in the offence. The right of the applicant to speedy trial has been violated. Learned counsel for the applicant aims congruency in role and seeks parity in relief granted to co-accused such and such, having been granted bail on such and such. The applicant has explained his criminal history. It is also contended that the applicant has become a soft target and a convenient scapegoat for the police authorities who nominated him in a number of false cases to burnish their professional credentials. The said cases do not have any bearing on the instant bail application. The applicant is not a flight risk. The applicant, being a law-abiding citizen, has always cooperated with the investigation and undertakes to cooperate with the court proceedings. There is no possibility of him influencing witnesses, tampering with the evidence, or reoffending. In the light of preceding discussion and without making any observation on merit, the bail application is
Now we put it to ourselves.
My lord.
The tripod test has been dealt with by the judge at all or not?
My lord.
Number one. Number one.
My lord.
Number two. Kindly come to page 13.
1-3, my lord.
Yes.
Great.
Ground G.
My lord. Ground G. Because the Honorable High Court erred in observing that accused number 2 is a law-abiding citizen who cooperated in investigation and had joined the trial proceeding. To the contrary, the Honorable Court.
Read slowly now.
I'm sorry. To the contrary, the Honorable Court has been misled as the accused number 2 was absconding. Non-bailable warrants were issued against him
Now, is it
and
correct?
he was declared a proclaimed
Is it
offender.
correct?
Now, my lords, FIR.
We are
is of
only asking
October.
you.
My lords, I will answer. I am answering that. I am explaining it.
1 minute.
My lords.
NBWs were issued against you.
Yes.
Your absconding.
Yes.
Bounty of 25,000 was declared.
Yes.
And it was only after rigorous effort that has been finally arrested from
My lords,
Kolkata.
October is the FIR. December, I have been arrested. 60 days. Within 60 days, my lords. I was up. My lords, in the process, I was.
Did you disclose this fact to the honorable judge?
My lords, this was. My lords, I'm sorry. I am failed to understand.
Did you disclose this fact in your bail application?
About, my lord?
About this ground G?
My lords, I have. My lords would kindly see. My lords would kindly see. Being absconding or issuing of non-bailable warrant would come in my way when it comes to anticipatory bail. My lords, I am in custody for last 6.5 years.
state, my lords, and he is actually a history cheater implicated in many
And we'll hear you later.
My lords may see
For
that.
this court, none has any problem or issue of not being heard.
Well,
We will not allow this interjection. Because had you been so concerned, you would have been standing on this side rather than.
Supposing, my lord, I have written that I am seeking time to file the counter.
We are saying you would have assailed the order of day. Had you been so concerned. That's what we are saying. Nonetheless, we'll hear you. Don't worry. Don't worry.
my lords,
Now, our query to you is read ground G and
Hello.
H, please.
my lords. H. Because the Honorable Court has.
Because your co-accused have also been absconding.
My lords,
Trial has not been progressing.
in fact, those who have been granted bail, he does not challenge those bail orders.
2018 FIR, the trial is not progressing only
My lord.
because of your reason.
My lords, I am in custody, my lord.
Gentlemen, you and your co-accused.
My lords,
And
there is no
therefore, you
evidence.
say that because of the time lag, grant me bail.
My lords, there is no
Thank you
evidence
very much.
connect
If you want
me
to
with
give your
that.
written submissions, please give your written submissions.
My lords, I will do that.
Heard. CAV and counsel for the parties are permitted to file the written submissions within 2 days.
If I may,
My lords, counter.
So, London Amicus, yes.
my lord, my report is there. Your Lordship.
What do you say?
Your Lordship's appointed me for responding.
We know that you're Amicus.
Your Lordship, the rigors of cancellation of bail as said by this Honorable Court are a little strict. I've highlighted all the orders.
So, no, what is your view?
Your Lordship's
As an Amicus, what is your view?
cancellation of bail, Your Lordship's curtails the liberty of an individual, Your Lordship, and it can only be exercised in extreme cases. Your
So, in this case, what is that you say the court?
Your Lordship,
should do?
my preliminary submission is that he is not been named in the FIR, Your Lordship.
Okay.
And as per the complainant only, it has been in his statement as improved because after filing of the FIR, when he gives his statement, he says that the deceased before dying took my name.
Okay.
But the same has not been mentioned in the FIR, you know.
Very good.
So that is.
State what you say.
My lords, I really need time to file counter.
Then we are
Yes, my
give
lords.
your written. Thank you. Give your written. It said
I will.
written submission within next 3 working days. Okay.
Great.
Both these matters, Malod, the respond number 2, Malod. In fact, the accused.
What rejoinder is required?
Malod, they had filed, Malod, the counter has been filed by the state, Malod. Only yesterday, Malod, 2 days back, Malod. And both the accused are, Malod. Well, I'll not press on that, Malod. In fact, Malod, the accused, Malod, they have not been served, Malod. That is the office report, Malod.
Accused have not been served.
Malod, at the given address, Malod, both are not available.
Service not complete.
Service may be directed to be effected through SHO concern.
Yes, Malod.
Respondent, as per office report, respondent number 2 could not be served. Service through SSP.
Yes, Malod. In both the matters.
SHO may do.
No. SHO, you said earlier, you are the state. Go ahead.
Oh, right.
Lord was pleased to grant that the counter is there, but Nidhi Jaiswal,
We'll just pass it over, someone may come.
please,
You just pass it over.
please.
Item 4.
Question has been already been.
Just 1 minute, sir. Service is, what do you say?
Malats, I for the state, Malats. Malats, I wish to place on record the statement of the victim categorically naming the petitioner herein, Malats.
August 24, now we can.
Yes. Malats, there is also a discharge application which has been filed by the petitioner.
Done and wait.
Right.
Wait.
Fine.
Lordship, the only problem is that despite
owner of the Iowa vehicle and the
owner of the stone crusher plant has been granted anticipatory bail, the driver has been granted anticipatory bail, my lord.
He is
And
not
the
joining.
No, my lord.
He is not joining. He is not joining the investigation, Your
Mr.
Lordship.
Counsel, Mr. Dwivedi, just 1 minute. He's still on the mistakes.
Okay, Lordship. Okay,
My
Lordship.
lord. While the anticipatory bail was
We know that the
before
driver,
junction could
we know that the driver and the mine owner has been granted
My
bail.
lord.
High Court asked you to surrender.
My lord.
Why is it that you have not surrendered?
My lord, on 15/5, I appeared.
Have you joined investigation?
15
No, Your
May
Lordship.
2024, I joined when I got the application 41A. I joined the investigation. Your lord.
After we granted order, have you joined investigation?
No. Day before yesterday, I got the instruction that he went to the concerned IO and he also asked for a proper.
Okay. Very good. Yes, Mr.
Lordship,
Dwivedi.
Lordship, if you had page 6 of my reply, I have categorically stated 41A notice was served on him to appear on 5th May and then on 30th July. On both the dates, he has not appeared.
Nahi. See,
The last being on 30th July, day before yesterday.
Mr. Counsel,
Lordship.
your counter, ma'am, you do one thing, file your rejoinder and immediately report. The
My lord, I will join the investigation and file a response.
petitioner shall.
No, there is allegation against you that despite you being informed by the IO to be present, you have not attended.
That is what I am putting on my lords. That day before yesterday, he went to the IO and he even asked that some
No, when
granted to
when
him, he has been present.
IO is giving you notice, summoning you, you are not appearing. And someday you are approaching yourself without being invited.
Earlier once I appeared.
And you say that when I went, they
May
didn't.
2024, I appeared, my lord. I am willing to appear. I am willing to.
Petitioner shall make himself available before the concerned IO on tomorrow at 10 a.m. The police station, which is the police station? Concerned police station at 10 a.m.
Azad Nagar.
In the meanwhile, rejoinder be filed within 1 week. List on dash.
Okay, Lordship.
Right.
Item 6.
Tomorrow and all subsequent dates as he may be required during the course of investigation. And we'll confirm. We're confirming the order. 7 p.m. Same order. We're confirming the able order.
Item 8.
8 same.
Much obliged.
Item 9.
For petitioner 9, my lord.
Yes, please.
My lord, says 69-year-old lady, my lord, says.
NBWs have been issued against you.
My lord, says 69-year-old.
NBWs have been issued or not is what we are asking.
My lord, I am requesting.
The High Court says that.
My lord, High Court says that, my lord, prosecution get against every accused in 15 days or in 20 days NBWs, my lord. My lord, I am requesting only she is ill and 69-year-old, my lord. And my lord, who sued the lady is not related to petitioner, my lord.
Gunshot injury है.
Lord.
Gunshot injury है, NBW है. और tell us.
My lord, is the neighbor, my lord, who is sued?
The FIR. Gunshot injury. You on your behalf and on your asking, the gunshot was fired.
My lord, who fired the gun, my lord? He is the neighbor of the complainant, my lord.
You satisfy us on two things. In terms of the FIR, alleged allegation, and that you have been absconding, NBWs.
Allegation due to my lord matrimonial dispute, she is making
only because you are a woman doesn't make you entitled for a bail. That's the case of
my lord, they want extort money only due to that falsely implicated in FIR, this FIR, my lord.
Allegation categorically against you.
My lord, only I was not there, my lord. My lord, I was not there and I am old lady, my lord.
How old are you?
69.
You are aged, infirm.
69-year-old and ill, my lord. So, my lord,
you surrender means your bail will be considered expeditious. Don't make that statement unless you're instructed. Sorry.
Item 10.
Please, petitioner is seeking for regular bail. Since last 9 months, he is in jail. Co-accused has been already released on bail.
Only thing is that it's a case of POXO. Allegations appear to be, it appears to be prima facie. On a bare reading doesn't appear to be,
Yes.
notice किया क्या नहीं?
नहीं. It's a fresh matter. May I request for a return?
Some date will be there, but be ready. Notice doesn't mean that we'll allow.
On which point I missed?
Victim is not a party.
She is a party. She is a party.
He's a party.
He is a party.
She is a party.
The only thing is that they will serve through the concerned association. Be ready. You see, when we went through the story, it doesn't appear to be plausible. But if she's 14, then there's a difficulty for you.
15, but it is a, with respect to may I submit, Lord, it is a matter of trial, her age, determination of her age, Lord. He's near about 15, but it is consensual. That is my respectful submission.
We have not dismissed it.
Yes.
We should notice, but we are telling you.
Yes, I will like it. Oblate.
Item 11.
Age 88, my lord, I am mother of 3.5-year-old child, my lord, baby girl, my lord. And Lord, this is the case where IPC is not made out, my lord. I am a nurse, my lord, I have got this.
Item 12.
Lord, this is fresh matter, the notice has not been issued, my lord.
जनाब नोटिस भी कर दिया, आपको ए बिल भी दे दिया. जाइए.
My last order also directed us to pay 25% of the amount of DA which to the employees.
No, sorry, which item?
Item 12.
Well, wait, sir.
I apologize.
Your Lordship, item number 12 I am.
Yes.
Your Lordship, the allegation against me, against the non-bailable section is that I have hit the pregnant woman on her stomach. Now, this allegation does not inspire.
This is a very serious allegation.
Your Lordship, this allegation does not inspire confidence, Your Lordship, because of the reason.
Why you tell us why it doesn't inspire confidence?
Because when she was in dire state, she visited a hospital.
Kindly come to page 11. Gentlemen, can anyone give a seat to Mr. Subramanian, please? Please. It's a pleasure and delight to be. Yes.
Yes, Your Lordship.
Yes.
Yes, Lordship. Page number 13 is the information.
No, gentlemen, you come to page 11. Why do you say
Yes, Your
that
Lordship.
ex officio it is false?
My point is, Lordship, when she was in the dire state, she visited a hospital which was 6 kilometers away from her place.
Gentlemen,
And when
the
she was
allegation against you is that you kicked her, which resulted into XYZ. We need not read the contents. It's horrible, horrendous.
Yes, Your Lord.
Thank you.
My Lordship, the point is, first she was referred. First, she went to Sadar Hospital, which was 6 kilometers away from her place. And when she was referred to RIMS,
Thank you, sir. Thank you. We are not. Thank you.
she visited the place which was nearer to her place.
Thank you, sir. Dismissed.
Application.
Because in this matter,
He is saying that they are not agreeing to pass out.
state is seeking 2 months time. We have formed a committee.
Yeah, we will request. Now we want to hear from you finally. Please proceed with the submission.
Well, as the amount is very large.
Mr. Singhvi, we are not adjourning the matter. We would want all of you to address us on merits.
Yes, please.
Please proceed with the submissions.
So
We especially kept this matter. Mr. Singhvi, we especially kept this matter. We told you previous occasion also.
Malas, may I say one thing?
Hear the matter.
May I say one thing, Malas? Number one, Malas, this may not be a conducive day for a Monday hearing.
No, it is all right for us.
Number two, Manoj.
In fact, today is the most auspicious day for us.
No, not auspicious. I'm only saying conducive, Manoj, not auspicious. Number two, Manoj, we need to.
Take the book of traditions, make a pyre of cliches, and burn it.
The smoke that emerges is what I become.
Order. The amount has to be worked out as per my Lord's orders.
For all you know, you may not have to pay a single penny. Let us submission.
Yes, sir.
Please, we are very clear. Please start.
Very well, then Manoj, we can start. If let me start, then Manoj, I join in then if he wants to start.
Yes, most certainly. Yes, Mr. Dwivedi, you start.
So, what we are submitting is this, not both the tribunal and the High Court said.
So you may, no. Minutes now.
Only one sentence, Manoj, I want to say before he starts. This I am saying that the High Court and the tribunal have both not quantified the amount.
Correct.
Therefore, your Lordship's direction, even for implementation in letter or spirit, requires quantification.
No, what we intend to do is we
Yes.
can see our restrictions have been complied with or not is not the issue now. The only thing is whether the judgment passed by the High Court is
Very well, let Mr. Dwivedi start, Manoj. Let Mr. Dwivedi start.
Yes, sir.
Or if you want,
to have it tomorrow on it.
tomorrow we have already 60.
Next week.
One minute. Are we adjourning the matter?
No, they said okay, sorry.
See, the issue is all very simple. We don't, as we understand, as we read, or as we have read, very simple. What is not what we have to examine, and we'll do it once and for all. Simple as that.
My lord, that simplicity is involved in every case.
Rest assured that none would have any grievance that we have not heard.
No, that's not the point, bro. The point is that
Therefore, we would request you to begin, please. Should you, we'll accommodate you. Perhaps we don't want you to be, caught in a surprise. We'll pass it over, and you come back at 12 o'clock, come back at 12:30. No difference. But we want you to begin. That's it. Or you may proceed, please.
I will be as ignorant, at 12:30 as not. Let me show you. Next Monday.
We may, Mr. Ahmadi is here. We made it clear last time also. We are not, we'll hear it. Mr. Ahmadi, correct us if we are wrong. But I thought.
Today only the IA is listed actually. So far as the IA is listed. No. That was my impression.
No problem.